So, in the order of importance, external aids to interpretation is the last one that the judges refer to. First, they have to refer to the literal edges, applying the literal rule. Then, if that is not enough, then we have other rules, certain other maxims that come to rescue. And if all that's not enough, then the judges look at other, aids available within the statute, ex visceribus actus. And then if that is also not enough, then the judges can then look at external aids to interpretation. They're external aids because they are not within the statutes. However, they have different values, different importance given to them, and we have discussed a few, and I had uploaded the recorded lecture yesterday. So today we are going to take up one more example of external aid, and that will complete this topic, that is external aids to interpretation. Today we are going to look at something called statutes in Pari Materia. So statutes, Pari Materia broadly means that statutes, different statutes, not the same statute, not the provisions, different provisions of the same statute, no, different statutes. So different statutes that deal with the same subject matter and that form part of the same system, So it's, so basically when you have two different statutes, maybe they are coexistent, but they deal with the same subject matter, then it might probably be required that judges refer to provisions in another statute dealing with the same subject matter in order to come to conclusions about what a particular provision, dealing with the same subject matter in another statute basically mean. Or it could also mean that there might have been a statute that existed prior to the extant statute. And in certain cases, the later statute could also help in interpreting. In certain cases, very limited cases, the later statute could also be of help in interpreting prior statute, so long as they deal with the same subject matter and they form part of the same systems. So that's the idea. So earlier we studied a rule that says that statutes are to be words are to be understood in their context. So within the statute, you look at the context of the statute, the word in the context of the statute. An extension of the rule is this, that you look beyond the context of the concerned statute, but also look at certain other, other statute that deals with the same subject matter. So it provides you the context. So it's an extension of that contextual interpretation that we discussed earlier. So Lord Mansfield in R versus Loxdale, just a second. In R versus Loxdale had said that where there are different statutes in Pari Materia, similar, material as I understand, but it is to be understood as we have just discussed. So where there are different, statutes in Pari Materia, though made at different times or even have expired. So it's possible that subsequently another, act has been, created that replaced a previous act. Even that situation, it is applicable. So, or even expired and not referring to each other, they shall be taken and constitute together as one system explanatory of each other. However, it's limited. It's not to be understood in that broad sense as, I've just quoted here. So so where there are different statutes in Pari Materia, though made at different times or even expired and not referring to each other, they shall be taken and constitute together as one system and as explanatory of each other. So if that's the case, then the statutes, because they are forming part of this same system, they are to be considered as statute Pari Materia. So what is Pari Materia? So when do we call statutes as being Pari Materia? So in US versus Eagle Bank 1829, it has been described, explained. Okay, so it says statutes are pari materia which relate to the same person or thing. Okay, so it relates to both the statutes relate to same person or thing, or to same class of persons or things. The word par must not be confounded with the word similis. Okay, so it's not merely similarity, it's the identity that matters. So it says further that it is used in opposition to the intimating not likeness merely, but identity. It has to be identical when it comes to the subject matter of the statute. So it is a phrase applicable to public statutes or general laws made at different times in reference to the same subject matter. So quite a clear definition. So it has to deal with the same person, thing, same class of persons or things dealing with the same subject matter. So it's not mere likeness but identity that matters. But you will see a kind of variation in that here and there. So that's how statutes pari materia is to be understood. However, if the statutes are of differing scope, okay, one broad, the other one is restricted, okay, then they are not in pari materia. So the scope has to be, same. So that's why the identity, not mere likeness. Because you know that quite often statutes are created with, general application, then you can have specific legislation which could be not in accordance with the previous general statute. So they might be applicable in exceptional situations. So those situations in which the laws are applicable might be exception to the general law as has been laid down in a previous statute. So that has to be kept in mind. Okay, the two statutes are to be of same scope. If they are of differing scope, then the rule of pari materia does not apply. However, at the same time, it does not say that it is not necessary that entire subject matter in the statute, is identical. It is possible that if you had a particular set of provisions in the previous statute that dealt with a particular subject matter, and then subsequently another statute that dealt with exactly the same subject matter, even if the entirety of the statutes are not identical, but if those specific matters are, subject matter identical, then in such situation also the statute pari materia rule is applicable. So I hope this is clear, the basics clear. Then we can have a look at few cases, and that will explain with certainty as to what it really means. So let's take the case of State of Madras versus Avir 1958. So in this particular case, we are concerned with two provisions of two different statutes. Okay, we are concerned with Indian Evidence Act 1872 section 4 refers to shall presume here. Okay, so it says whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved. Okay, shall presume is to be a fact is to be construed as the such fact as proved unless and until it is disproved. So the assumption is that it is proved. And then we have section 4 Prevention of Corruption Act 1947 that deals with presumption where public servant accepts gratification other than legal remuneration. So we are concerned with these two provisions. So section 4 of Prevention of Corruption Act that I just read out to you. So it directs that on proof that the accused has accepted any gratification here, public servant, okay, other than legal remuneration, it refers to shall presume here as well. So it shall be presumed unless the contrary is established by the accused that the gratification was accepted as a bribe, has been held in pari materia with the subject matter as we found in section 4 of Indian Evidence Act. The presumption here is the same here. Okay. And the definition of the expression shall presume, as I just read out to you in the Evidence Act, has been utilized to construe the words "it shall be presumed" in Section 4 of the Prevention of Corruption Act. So the similarity here, okay, of these two different provisions had allowed the courts to look at a previous, act, okay, and then find the meaning of a later provision in a later act, okay, because these two statutes, especially these provisions, are in Pari Materia. Another example would be is by the name Kusum Ignatz and Alloys Limited versus Union of India 2004. There are many other cases you can look at. I found the ones which are explainable and understandable. So you can also refer to other cases. So in this particular case, we are concerned about two different provisions from completely different, laws. So first we are concerned with Section 20 of CPC. It refers to other suits to be instituted where defendants reside or cause of action arises. Okay, so it says, subject to the limitation aforesaid, every suit shall be instituted in court within the limits of whose jurisdiction the cause of action wholly or in part arises. So this is what concerns us. A jurisdiction where the cause of action wholly or in part arises. Likewise, Article 226(2), Clause 2 in the Constitution of India, it refers to the power conferred by Clause 1 to issue directions, orders, or writs to any government authority or person, may also be exercised by the High Court exercising jurisdiction in relation to the, again, see, the territories within which the cause of action wholly or in part arises. For the exercise of such power, notwithstanding that the seat of such government authority or the residence of such person is not within the territories. So it's based on cause of action wholly or in part. So in this case as well, okay, so Section 20C of the CPC and Article 226 of the Constitution have been held to be in Pari Materia, and decisions interpreting the former, that is Section 20 of CPC, have been held to apply in interpreting the later, that is Article 226(2), for deciding the place or places where the cause of action wholly or in part arises. So because they are in Pari Materia, so decisions with respect to the previous has also been held applicable in the later. So that's how this rule broadly works. Now, you see that so far our examples have been of, how provisions and their interpretation in a previous act has been, held to be applicable in the later. However, it is also possible that related provisions of different acts, okay, that has effect on the same subject matter, okay. It might be necessary that both the provisions of two different acts are read together. Okay, even though they are separate acts, they infuse meaning to each other. Okay, and we have to read them likewise. Okay, so provision of one particular act might be necessary in understanding provision of another act. Now that's not really a case of Pari Materia, as you see, because the provisions of this statute, even if they do not refer to each other, might be of such a nature that they deal with similar situations, same subject matter, and it is necessary for us to refer to each other. So you can broadly say that, well, that could also be considered as a case of Pari Materia, statute Pari Materia. So an example of that would be Common Cause, a registered society versus Union of India, in 1996. In this particular case, we are concerned about Section 77(1), Representation of People Act, okay, and explanation 1 to that particular section. So Section 77(1), Representation of Peoples Act, deals with Representation of People Act 1951, refers to what shall not be deemed to be expenditure in connection with the election incurred or authorized by the candidate. So the expenditure in connection with election incurred, okay, authorized by the candidate, that shall not be considered as an expenditure. So, and explanation 1 to that basically gives you an illustration. Okay, so what does it say? Explanation. So the explanation provides that any expenditure incurred or authorized in connection with election of a candidate by a political party shall not be deemed to be expenditure in connection with the election incurred or authorized by the candidate. Okay, so it has been made by the political party, so will not be considered as expenditure in connection with the election incurred or authorized by the candidate. And then we have two other provisions from Income Tax Act 1961, Section 13A and Section 139(4)(b). So what do they deal with? So Section 13A deals with special provision relating to incomes of political parties. Okay, so it says any income of a political party which is chargeable under the head income from house property, income from income from other sources, or capital gains, or any income by way of voluntary contributions received by a political party from any person shall not be included in the total income of the previous year of such political party. So an exemption provided. Further says that provided that such political party keeps and maintains such books of account and other documents as would enable assessing officer to properly deduce its income. So even if it is not chargeable, okay, but assessment has to be there. Otherwise, how else do we ensure that black money, doesn't make its way into funding political parties? So similar provisions are also there, okay. And then you have 139(4)(b) Income Tax Act, and it lays down the provisions for filing income tax returns for political parties. And according to it, if the income tax exceeds maximum allowable tax exempt limit, they are required to furnish tax returns. Also, so mainly 13 A's of concern here, along with 139(4)(b) of the Income Tax Act. Now, what is the problem? So you see that they are referring to the same matter here. Okay, the same issue here. So, in considering the provision, okay, that is Section 77(1) of Representation of People Act, the court read Section 13A and 139(4)(b) of the Income Tax Act, which though exempting the income of political parties from house property, other sources or voluntary contributions, require them to maintain audited accounts and file the income tax return for each assessment year, even though it is not chargeable. Okay, so but a return is to be filed. So the court further held that if a political party is not maintaining audited and authentic records and is not filing return of income, it cannot justifiably plead that it has incurred or authorized any expenditure in connection with the election of a party candidate within the meaning of explanation 1 to Section 77(1). That's the exemption you have there. So filing is necessary. So you see that provision in one particular statute, okay, is given meaning to in the light of provisions of another statute, if they refer to the same subject matter and deal with the same issue, and also the same person or class of person here. So they are clearly statutes in Pari Materia, but they are both extant statutes. So that's another example of statute in Pari Materia. Now, this is understandable because both the statutes are extant, okay, existing at the same time, although created in different times. Now, we'll look at the situation when assistance can be taken from earlier statutes in interpreting provisions of a later statute. Okay, so the rule of Pari Materia permits the raising of a presumption in the absence of any context indicating the contrary intention. So it is possible that later statute clearly departs from how a particular word expression was understood in the earlier statute. Okay, so if that is clearly apparent, then obviously there is no reason to refer to the similar provision in a previous statute. That's clearly understandable. So that's why it's being said that Pari Materia permits the raising of a presumption in the absence of any context indicating contrary intention, that the same meaning attaches to the same words in a later statute as in an earlier statute if the words are used in similar connection in two statutes, and it enables the use of a later statute as parliamentary exposition of the meaning of ambiguous expression in an earlier statute. So it says it enables the use of later statute as parliamentary exposition of the meaning of ambiguous expressions in an earlier statute. So basically broadly says that what was decided in the previous statute. So for example, there was a particular provision in the previous statute that has been judicially analyzed, interpreted, and subsequently another statute has been enacted replacing the previous one, but it does not deviate, okay, it does not say that, well, it's not in agreement with what was there, okay. Such contrary intention is not there. In such case, the later statute can be understood and interpreted in the light of the previous, earlier statute. So it says, when the words in an earlier statute have received an authoritative exposition by a superior court, use of the same words in similar context in a later act will give rise to a presumption that Parliament intends that the same interpretation should also be followed for construction of those words in a later statute. So yes, judges understood a particular word expression as something, okay, as they have interpreted in a previous case, or in series of previous cases. Subsequently, Parliament enacts a legislation, but does not say that it is in opposition or to how it has been understood. Okay, it does not clarify anything of that sort. Then the understanding would be that the later statute, when it had been enacted, had been done keeping in mind the interpretation the word had received in previous cases. So yeah, so that's the rule when it comes to interpreting a later provision in a later statute with the assistance of an earlier statute. So Justice Griffith had said that when a particular form of legislative enactment which has received authoritative interpretation, whether by judicial decision or by long course of practice, is adopted in the framing of later statute, it is a sound rule of construction to hold that the words so adopted were intended by the legislature to bear the meaning which has been so put upon them. Because we assume that the legislature is not starting like in vacuo with a clean slate. They bear in mind how a particular statute or provisions in a statute had been understood. But there is an opposing view as well, that when most people do not know of the existence of the old laws, why should we assume that the legislature was also aware? So that view is also there. However, that's the broad idea, okay? So Lord Macmillan in Greaves versus Stofields, 1880. Let me just type it here just a second. So yes, in Greaves versus Stofield, Lord Macmillan had said, if an Act of Parliament uses the same language which was used in a former Act of Parliament referring to the same subject matter and passed with the same purpose and for the same subject, the safe and well-known rule of construction is to assume that the legislature, when using well-known words upon which there have been well-known decisions, uses the words in the sense which the decisions have attached to them. So in those cases where it is clear, okay, this particular assumption applies. The same rule has also been applied in India in the famous case of Bengal Immunity Company versus State of Bihar, 1955. In this particular case, Justice Venkatramaiah had observed that it is a well-settled rule of construction that when a statute is repealed and reenacted, and words in the repealed statute are reproduced in the new statute, they should be interpreted in the sense which has been judicially put on them under the repealed act. Because the legislature is presumed to be acquainted with the construction which the courts have put upon the words, and when they repeat the same words, they must be taken to have accepted the interpretation put on them by the court as correctly reflecting the legislative mind. So the same rule as has been applied in India, as has been understood and applied in India as well. However, the word of caution is that not necessary in all cases, though we are not to assume that the legislature in no way can differ from or deviate from how law has been understood earlier. It's very much within its power. So unless that is clear on the face, then it is okay for the courts to have that presumption. So that's when statutes are in pari materia. So there are situations when the statutes are not pari materia. So basically when those requirements are not fulfilled, then they are not pari materia. So when a new statute is passed with new objectives, okay, as opposed to what we have studied, then the presumption does not arise. Okay, then the statutes are not pari materia. If the objectives are new, then we are to assume that the legislative intent is also different. And it is also possible that times have changed, social views have changed. Okay, in that situation also the judges have to be chary about going ahead with this particular rule. Okay. And when there is no ambiguity, if the words are crystal clear, okay, there is no ambiguity, then that word is not to be limited or given a different meaning to, because how it has been understood in a previous statute. And when statutes are in different states, okay, so in that situation also the rule does not apply. So, and obviously, if there is a serious change in the language used in the later statute, okay, in that situation also it raises serious doubt about whether it is in pari materia or not. So judges have to look at the language as well before they decide whether they are in pari materia or not. So that's the rule. So Justice Brett in Dickerson versus Fletcher, 1873. Yes, in this particular case, Justice Brett says that when two statutes dealing with the same subject matter use different language, it is an acknowledged rule of construction that one may be looked at as a guide to the construction of the other. If one uses distinct language, imposing a penalty under certain circumstances, and other does not, it is always an argument that the legislature did not intend to impose penalty in the later. So see, if the language varies, the same, it is not to be understood in the same way. Why? For where they did so intend, they plainly said so. If they didn't, then why are we going to assume that they meant the same thing in both the statute? So that's the rule. In another Indian case by the name Western India Theatres Limited versus Municipal Corporation of Pune, AIR 1959. In this particular case also, the rule has been applied. So you see that in this particular case as well, you see that there is a minor change in the language, and that change in the language itself raises presumption against it being completely in pari materia. So here the substitution of the word I reduce by the word I modify in the body of section 60 of the Bombay Municipal Boroughs Act 1925, notwithstanding the omission to do so in marginal note. Therefore, obviously marginal note is not to supersede the enacted provision. So that's there. Notwithstanding the omission to do so in marginal note, therefore, clearly indicated the intention of the legislature to widen the scope of that section. And consequently, it could not be said that the enhancement of the tax was not anyway, whatever. So what is to be seen here is that if different words are used, legislature might be intending something else. So here the intention was to widen the scope. Now it is not to be understood in the light of the words used in the previous statute, and hence reduce the scope. That will not be justified. So changes in language have to be kept in mind by the judges as well. Now, yes, assistance of earlier statutes makes sense. What about assistance of later statutes? Can an earlier statute be understood in the light of the later statute? Well, if subsequently any clarificatory legislative development happens, then obviously that is quite clear. It will refer to the previous statute and then explain that, well, this is how it is to be understood. That's there. However, what about legislation that existed earlier and then legislation that came later? How about assistance of the later statute in understanding the meaning of a word in a previous statute? So a legislation proceeding upon an erroneous assumption of the existing law, okay, without directly amending or declaring the law is ineffective to change the law. It says that a legislation proceeding upon an erroneous assumption of the existing law without directly amending or declaring the law is ineffective to change the law. So if it is erroneous in its assumption about the existing law, then it intends to bring about changes or in the law, will be ineffective because it was wrong in the first place. It was wrong to begin with. Okay, so it has been said in IRC versus Dowdall Mahoney Company Limited. So yes, subsequently a law may be enacted, but if it was based on the wrong presumption of erroneous presumption about the existing law, then it will have no effect. So in this particular case, it has been said that beliefs or assumptions of those who frame acts of parliament cannot make the law. So if their beliefs assumptions are wrong, that will not change the law. So a later statute is not normally used as an aid in the construction of an earlier one. It does not happen quite often. Okay. So it has been said by Justice S.K. Das that legislation founded on a mistaken or erroneous assumption has not the effect of making that law which the legislature had erroneously assumed to be so. The court will disregard such a belief or assumption and also the provision inserted in that belief or assumption.